Washington. As John Eastman prepares surrender to Georgia officials last week for an indictment for his efforts disrupt the 2020 presidential election, he issued a statement denouncing the criminal case targeting lawyers for their zealous advocacy on behalf of their clients. Another defendant, Rudy Giuliani, said on a similar note that he was indicted for his work as Donald Trump's lawyer. "I never thought I would be accused of being a lawyer," he complained. More than half a dozen attorneys are among the 18 defendants charged with Trump in this month's racketeering indictment in Fulton County. Eastman and Giuliani's statements are early precursors of at least one of the defenses seem poised to raise they were simply doing their job as lawyers as maneuvered to roll back the election results for Trump. This argument suggests Trump's desire to turn at least part of expanding investigation into a referendum on the limits of ethical advocacy, in a case that re-emphasizes how his own lawyers have become involved in his own legal problems over years. But while lawyers have ample room advance untried or unconventional positions, experts say a lawyer's defense will be successful to the extent that prosecutors can directly link accused lawyers' criminal plots alleged in indictment. This includes their efforts to line up fake voters in Georgia and other states to claim that Trump, not Democrat Joe Biden, won their own contest. The law books are full examples of lawyers being disciplined for claiming to represent their clients, said Barry Richard, who represented the winner George W. Bush's presidential campaign in 2000 in a dispute ultimately settled by the Supreme Court. Lawyers have to follow very strict etiquette rules. And there are some things you can't do for your customers. George Washington University law professor and former Justice Department official Stephen Saltzburg said a more complex question is how far lawyers can go in advancing legal theory to achieve the desired outcome for their clients. Bad lawyering is not a crime per se. And neither is it testing the waters of reasonable advocacy. He said, the real question is at what point does a lawyer cross line knowing that the legal theory adopted by lawyer has never been accepted anywhere. And that's a blurry line. Of course. As Eastman stated in his statement, lawyers are expected to represent their clients with enthusiasm. However, according to court documents, he had privately admitted that he expected the Supreme Court unanimously reject the idea that then Vice President Mike Pence could reject it. Counting of electoral votes. There is also a long history of electoral lawsuits. None more famous than the 2000 Florida fight between Democrat Al Gore and Bush's campaign. Justice Department Attorney Jack Smith acknowledged this in his federal indictment against Trump, saying that he, like other candidates, has the right to file lawsuits that challenge voting and procedure and